Welcome back to Morning Live. Now, former President Jacob Zuma and the Department of Correctional Services are expected to appeal yesterday's Pretoria High Court judgment, which nullifies the department's former Commissioner Arthur Fraser's decision to grant Zuma medical parole. Now, the court ruled that Zuma's release on medical parole was unlawful and ordered that he be sent back to jail to complete his 15-month jail term. The application was brought by the Democratic Alliance, the Helen Suzman Foundation and Afriforum. Legal commentator Ulrich Roux joins us now to help us unpack more of this particular story. Thanks so much for your time this morning, Ulrich. Welcome to Morning Live.
Hi, good morning. Thank you for having me.
And of course, this is one that is in the public interest. The entire South Africa, always seems to be drawn into matters around decisions on the former president. But let's just get your preliminary reaction and assessment of this particular judgment.
Well, I think let's go back to when medical parole was granted to Jacob Zuma. Remember that he had found to be in contempt of a constitutional court order, and the court, which is our highest court in the country, ordered him to serve a period of imprisonment of 15 months. He then served approximately 2 months of that prison sentence, and then he was released on medical parole. And it was a decision that was made contrary to the advice and the recommendations that was provided by the Medical Parole Advisory Board. And in this instance, the Commissioner of Correctional Services, Mr. Arthur Fraser, went over the heads of the Medical Parole Advisory Board and granted Jacob Zuma medical parole in terms of Section 79 of the Correctional Services Act. The DA and the Helen Suzman Foundation, as well as Afriforum, lodged respective urgent applications to review and set aside that decision by Arthur Fraser. And the court yesterday handed down a decision saying that Arthur Fraser, in fact, never had the capacity or the expertise or the ability to release Jacob Zuma on medical parole, that it was not a rational decision, and accordingly set aside his decision to release him on parole. And having studied the judgment handed down by Judge Matajan yesterday, I must say that it is a very sound judgment. It was a judgment which took the judge approximately 3 months to compile, and in law, a very sound judgment. I think that the most important points that he highlighted was that the decision to release a person on medical parole is a decision that vests purely in the Medical Parole Advisory Board. And that board had considered Jacob Zuma's application to be released on medical parole and had found, based on the evidence presented to them and the facts before them, that he was not a person who qualified for medical parole. And accordingly, Mr. Arthur Fraser's decision, remember that he was then the Commissioner of the Department of Correctional Services. He is no longer in that position, and that his decision was not a rational one and accordingly had to be set aside. I think the correct decision made by the court, but of course, Jacob Zuma has already indicated that he is taking that decision on appeal, so we'll have to wait and see how things unfold now again.
So just looking at that judgment and, of course, the fact that the former president and, of course, the Correctional Services Department will be appealing this decision, looking at the issue of medical parole. Now, the judgment also outlines the reports that were submitted to the parole board. And there's, of course, the report from the South African Military Health Services, Dr. Mafa, and that was submitted. And also one of the doctors on the medical parole board itself also inspected and examined, I should say, the president, and also, gave his opinion to the parole board, which, of course, was overruled. They found this to be insufficient and had asked for even more evidence. So looking at that information in terms of just the question of medical parole, do you think that that will stand the former president and, of course, the Department of Correctional Services in any good stead going forward, saying that, but there was evidence from different doctors that supported the medical parole for the former president?
Well, remember that they had to prove that he was a person who suffered from a terminal illness, and that as a result of that illness, he was not able to function within the Department of Correctional Services and go about his daily activities, being a prison inmate and under the control of the Department of Correctional Services. And upon those medical reports, of course, there were reports which confirmed that he does suffer from some medical conditions. But let's be honest, most people, if you had to scrutinize them, who are Jacob Zuma is almost 80 years old. There's obviously some underlying medical conditions. Most people will, present some sort of medical difficulties. But the test is whether that affects his daily activities and going about his daily life whilst under the control of the Department of Correctional Services. So yes, there might be medical evidence, but it was not convincing enough to convince the Medical Parole Advisory Board that this person needs to be placed under house arrest and he needs to receive permanent medical care, because he will not be able to function within the Department of Correctional Services whilst being imprisoned. So I think that the fact that Mr. Arthur Fraser is obviously not a medically qualified doctor. He will not be seen as an expert in the eyes of the court. He does not possess over the expertise to determine whether a certain medical condition prevents a person from serving a period of imprisonment. But the Medical Parole Advisory Board does. And accordingly, the court will always attach more evidence to what the board says than to what the Commissioner of the Department of Correctional Services will say. So he will obviously rely during his appeal process on the medical reports, as you highlighted now, which says that there are some underlying medical conditions. But I don't think that outweighs the fact that a board of experts adjudicated those reports and found that, yes, there might be some conditions, but he is still a person who is able to serve a period of imprisonment.
Notwithstanding, of course, the fact, as I pointed out, one of the doctors on that board had agreed with the military health services regarding this particular matter. But that aside, the parole board makes a decision. Arthur Fraser then decides, they make a recommendation, he makes the decision. What are his powers? Did that final power lie with him, Arthur Fraser, as the commissioner, to actually make that decision? What are his powers here?
So Section 79 of the Correctional Services Act does grant him certain powers when a decision is made to release a person on medical parole. But those powers are not automatic, and they do not supersede and completely disregard the findings of the Medical Parole Review Board. And that is what the court found in its judgment as well, that yes, he does have the power and he can provide input in such a decision, but ultimately all of the factors need to be taken into consideration in terms of Section 79. And the Medical Parole Advisory Board is the only statutory body who can ultimately decide whether a person is released on medical parole or not. And the court made that 100% clear. The court found that his decision to set aside the findings of the Parole Review Board or Advisory Board was unlawful and accordingly unconstitutional. It is not an automatic and autonomous right that he has. He cannot simply disregard all of the evidence presented to him, and that his decision was not a rational one. So yes, there are some powers vested with him, but they are not the be-all and the end-all. He needs to take into consideration all of the factors and the evidence presented to him, and the court found that he did not do so, accordingly reviewing his decision and setting it aside.
Ulrich, just curious in terms of legal precedent in a case such as this with medical parole being granted and then overturned. Anything come to mind? Anything that you could share with us?
Yes, so remember that any prison inmate is at all times full within his rights to bring an application to the Medical Parole Advisory Board as well as to the Parole Board once he qualifies as a person who is to be released on parole. But remember that that is not just an automatic decision that takes place. There's numerous factors that needs to be considered by any parole board, whether it be medical or otherwise, to determine whether a person should be released on parole or not. In this instance, we have seen numerous cases where a person has in fact qualified for medical parole or parole, and where it subsequently was discovered that either that person misled the parole board or the medical parole advisory board, and accordingly their parole will be reviewed and set aside, and they will once again become a prisoner who's under the control of the Department of Correctional Services. Some high-profile cases which immediately come to mind was, of course, the Oscar Pistorius matter, as well as the matter that involved the so-called Waterkloof 4, who were the youngsters. They were aged approximately 16 and 17 when they were found guilty of murdering a homeless person. They had initially qualified to be released on parole, and that parole was then set aside, and they were once again had to hand themselves over to serve their period of imprisonment. So it does occur quite often. It is obviously a contentious issue. Oscar Pistorius' parole is once again coming up now, and the most important factors that are going to be considered there is whether he has shown sufficient remorse after having been found guilty of the murder of his then girlfriend Riva Steenkamp, but also the opinion and the effect that his release on parole will have on the family of the deceased person. And these are all moving factors. It is not just a simple a list that you need to tick the boxes. There are various factors that need to be considered when a person is regarded or is scrutinized and his application is taken into account to be released on parole. And it is always going to be a contentious issue, there's no doubt. So the most important factors, coming back to your question, whether this is new precedent, is the fact that the High Court found that the only statutory body who can effectively grant a person medical parole is the Medical Parole Advisory Board. And accordingly, the powers of the Commissioner of the Correctional Services has been curtailed somewhat and has been limited to a large extent by this judgment.
Ulrich, we'll leave it there for today. Thanks so much for your time on this public holiday. Hope you enjoyed the rest of it. And that, of course, legal expert Ulrich Roux, providing his expertise following an order of the Gauteng High Court that former President Jacob Zuma should go back to prison to complete his 15-month sentence for contempt of court.